Okay, get started. I'm sure more people will arrive. Good evening, everyone. Welcome to tonight's event on remote advocacy. I'm Emma Jeffrey, the Assistant to the Director of Membership and Education. This evening's event is a discussion on remote advocacy with a panel of very distinguished guests, including Judge Walden-Smith, Judge Afzal, Judge Cawson, Master Shuman, Alice Hawker, and Michele O'Leary. David Mohyuddin QC will chair the event. The talk will be followed by a Q&A session, and for this we have many excellent questions, which some of you submitted when you registered for the event. If possible, if we have time, we'll also open up the floor for more questions using the Q&A function. The Q&A function can be accessed on the Zoom menu bar. You just click on Q&A. We ask that you please put your questions in the Q&A, not the chat, so that speakers can see them easily. This function also allows you to ask anonymous questions, should you prefer. If you have any general comments or questions not related to tonight's topic, please put those in the chat and I will try and answer any questions you have. If you have any problems with your internet connection, we suggest making sure that no one else is streaming in your household and, if necessary, logging off and logging back into the webinar. If your problems persist, you can email us at education@lincolnsin.org.uk. If you have any feedback about the event, we would love to hear it. Please let us know via email at education@lincolnsin.org.uk. We will be recording tonight's event and the video will be put up on the INS media page tomorrow, and we'll make sure to share the link on the INS social media as well. On behalf of the INS, I'd like to thank David and all of the panelists for giving us their time and expertise this evening, and thank you everyone for joining us. I'll now hand over to David.
Thank you, Emma, and good evening, everybody, and welcome to this remote advocacy event. I'm delighted to chair this evening's event and to welcome, as Emma says, a very distinguished panel of speakers. We're going to start with His Honour Judge Fayyaz Afzal CBE and Michele O'Leary talking broadly about their family experiences. Judge Afzal sits in Derby doing exclusively family and court of protection work. Michele is a full-time barrister in family work and also sits as a deputy district judge of the principal family registry. Once they have spoken to you, we're then going to move to civil matters with His Honour Judge Mark Cawson, Queen's Counsel, who is a specialist business and property courts judge based in Manchester, and Alice Hawker from Selborne Chambers. When they have finished their presentation, I'll move to Her Honour Judge Karen Walden-Smith, who is the DCJ for East Anglia based at Cambridge, and we're going to hear from her about appellate advocacy. And then joining us for the Q&A session afterwards is Master Karen Shuman, and of course, having not spoken, I will direct my first question to her. So thank you again, everybody, for joining us this evening. With that, let me hand over to Judge Afzal and Michele O'Leary.
Thank you very much, everyone. I'm very pleased to be part of this panel, so I can assist you, I hope, with some rules and advice on family advocacy from a family judge's point of view. And of course, I share this segment of tonight's session with Michele O'Leary, who also will share with you her perspectives from a family barrister's point of view, and of course, her perspective from a judicial point of view as well. So I hope that between us, we will be able to assist you with some specifics relating to family. But before I deal with the specifics, there are some general points that I'd like to discuss with you. Firstly, the right hardware for participation in remote advocacy. And you may need two computers, one for the purposes of taking notes and accessing bundles, and the other for accessing the hearing. And it can have a huge benefit because you can then position the computer you're using for access to the hearing at the right height, and also you're not typing on it. And one of the big bugbears as a judge, I find, is when you hear people tapping away at their keyboard, and that avoids that risk for you. You can also have a headset to improve sometimes the diminished sound quality that you might experience because of other people's broadband width, etc. And also because your microphone may not sometimes be the best, and that also assists as well. And also to ensure that you have the right broadband width to make sure all of those things work. Secondly, think very carefully about soundproofing and where you're delivering your remote advocacy from. Think about hard floors and echoey rooms, for example, and turn off audio feedback on messages that you receive. One of the things that I find most frustrating is when you constantly hear the pings of emails coming in for people. And of course, at the moment, with everything being on a remote basis for everyone, the email traffic can be quite significant. So do watch out for those audio prompts when emails are coming through. Thirdly, be conscious of your surroundings, careful about what can be seen around you. You don't want, particularly as family advocates, any family photos, for example, being on display, because that could be problematic from a whole array of perspectives. Neutral backgrounds are always very helpful, and they're not distracting for anyone else trying to study what's on your bookcase or and things like that. And obviously, as we know from recent times, avoid pictures of cats and things like that, for example. Fourthly, make sure you have your bundles readily accessible, if that means you have them in print, if you prefer, or you have them electronically, as most of people do these days. You're able to have them, but a very useful point for preparation. Not only is the bundle reference useful, for example, section C1 or E29 for something within that, or D29 for the care plans, but also have the electronic page reference number, because it is sometimes the case that if the bundles are properly configured, you can say, I'm referring to, for example, the Guardian's report E12 of the bundle, which is page, for example, 312 of the overall bundle, and that helps everyone from a navigation point of view. And keep, fifthly, referencing and the need for people to go to elements of the bundle to the absolute minimum required, and be ready to read passages to witnesses if they so require. So those are some general points. Turning to some quickly to some specifics. Firstly, make sure at the beginning of a hearing that you can see people and they can see you, and equally you are all each able to hear. Don't wait until the judge arrives for the testing element to take place, because often you'll be there before the judge arrives, joining the Microsoft Teams meeting, Skype meeting, or the CVP platform that's used. Secondly, send the link on to your own participants from the hearing if that hasn't already occurred, and make sure that they're present at the start of the hearing, and liaise with the judge's clerk if necessary. And thirdly, if you're for the applicant, make sure you have the cast list as you would in a non-remote hearing environment, so that you're able to introduce those who are present by remote link, and of course to emphasize how they are participating. So if they're on the video link or on the telephone dialing into the hearing. And also, fourthly, when you're addressing somebody on the remote link, pin their picture as the main picture on the screen, so that you're actually able to, whether that be the judge or the witness, to see if they're still talking and how your advocacy is being received, because of course there is that feedback, isn't there, from seeing the person whom you're addressing. And you can also gauge if they're about to speak, for example, and very much so, if the judge has got their hand up like that saying, stop, stop, whoa, you'll be able to see them more clearly, rather than that being the sea of small pictures at the bottom of the screen. Fifthly, speak slowly at an appropriate pace, and that, of course, is a matter of generality. Turning to, very quickly, witness handling and specifics that you have to consider. Firstly, make sure you have a focus and clear purpose in the questions that you're asking. And that can be in the family jurisdiction with reference to, say, in a public law case, the threshold criteria and which fact you're dealing with, or in a private law dispute, say it's a domestic abuse trial, with a reference to which allegation that you're dealing with. So everyone is signposted and taken along with you. So you can say, now dealing with allegation 1, my questions are going to be, and that way everyone knows where you are. Keep it relevant at all times. And secondly, in the remote platform, short, precise questions become so important. More so, I find, than hitherto, because witnesses and sound quality and varying connection means that if you ask a very, very long question, people might have heard the beginning and the end, whereas if your question's about 5 words long, you're going to be pretty confident that you've got it across, or if you need to repeat it, you can actually do it with ease rather than having to remember the very long, wordy question. So on a remote link, those are some specific considerations. Thirdly, retain a very good note. It's not so easy to check when you're participating remotely, whether you've got the note accurately, much as you would do if you're all along the front bench. And fourthly, make sure you're able to take instructions. So that can be by way of email or text, but there needs to be a method whereby you're able to check on an ongoing basis any updating information, and particularly when you come to the end of your questions. And don't be afraid to say to the judge, may I just switch my camera off for a moment and mute my microphone whilst I check with my client, as you would in court, almost the question of turning your back whilst you do so. And fifthly, never forget the normal rules of advocacy still apply. It's just a different platform with some additional considerations, but the room for deviation from the strict rules of advocacy, I find, are a lot less, and those who deviate find themselves struggling more so than they would normally. So those are some general points, some specific points. I know I've had to canter through them, but I'm hoping that the points I make would be of help to you, and I'm sure that others will emphasize and re-emphasize some of those points, and of course add to that as well. In terms of, in very short form, the things I find most challenging as a family judge on the remote platform is making sure that everyone is present, everyone is able to see and hear all the time, and making sure at all times that I'm presiding over, above all, a fair hearing. And that happens through working with everyone. If everyone does some of the, and hopefully all of the things that I've referred to and more, it can work. And I find that remote hearings can be, in the right circumstances and properly managed, highly effective. So I see a place for them in the future, not for every type of hearing, but certainly they are here to stay in some form, certainly in the family jurisdiction. And I really do like them for case management hearings, for example, in particular. And experts have always routinely given evidence on a remote basis, and therefore I think they can have huge benefits. They do have drawbacks in some respects when using, for example, interpreters, where you've got to go through the extra exercise of having breakout rooms, which are a little bit more technologically challenging, but manageable nonetheless. But certain types of cases just are not suited. And in those cases, we have, as you'll be aware, hybrid hearings, where those who must be at court are at court to ensure that fairness. So I really hope that helps. I'll hand over now to Michele O'Leary to assist you further.
Good evening, everybody. I'm going to cover 3 topics in what I have to say, and there will be quite a lot of overlap with Fayyaz and all his remarks, all of which I have to say I entirely agree with. 3 topics, and I'm going to help you remember them by saying barrister still remotely. That's what you are, that's what you remain. Barrister still remotely. Barrister stands for B. B is my first topic. B is be prepared. Be prepared, of course, means know your case. I would hope I wouldn't have to say to anybody here that you can get away with not knowing your case. You must know your papers, know your case very well. But it is also making sure that you know the platform you're on. Now, I'm talking to you more from the barrister's perspective, but these cases they're stressful for everybody, and that's recognised, but they are particularly stressful for the litigant who may very rarely join anything remotely, may not have access to an electronic bundle. So part of being prepared is making sure that the litigant understands whether it's a telephone hearing, whether it is CVP or Zoom or Teams, and can literally get on board. That being prepared stays in the course of the hearing. You do not want your client to have dropped out after 10 minutes and then you only realize that that happened at lunchtime. That's not doing him or her a good service. So you need to keep your eye on every participant who is there. And if for some reason your client drops off, then make jolly sure that the court is aware. Nobody will criticize you for interrupting, whether that means you end up frantically waving at the judge to say, look, I'm awfully sorry, but Joe Bloggs is no longer in the hearing. Nobody will want that to happen. And if people are concentrating on the case, they may not have noticed. So be prepared covers an awful lot of things. Make sure as well that on whatever platform you are properly visible. In other words, you've sorted out your lighting as best you can. You've either allowed in more daylight or kept it out. You've got if you're particularly vain, you may have a ring light to illuminate you. But so that you've done it so that what you have to say counts, can be heard, and that you can be seen. That carries on being important. A barrister is trying to persuade in his or her advocacy. That hasn't changed. That is every bit as important remotely as ever it was. If you're having an advocates meeting, which often happens in family cases in advance of a hearing, a pre-hearing discussion, make sure you know what platform that is on and that it's different. You need to make sure, as Faisal said, you need to make sure that you have a means of communicating with your client, if that is possible. That is difficult if it's a telephone hearing, and telephone hearings still exist. So do bear that in mind. And if it means you have to drop off a call so that you can check with a client, do so, rather than allow an injustice to take place. So be prepared covers a lot more than it always has covered in preparing for a case. Barrister still remotely, still slow down. Never forget in advocacy that you know your case inside out and back to front. But if it's a case management matter, it may very well be coming in front of a judge who has a list of a number of cases and won't be entirely on top of every nuance that you are speeding through at the rate of knots. If you can't be heard and understood, you're not going to persuade anybody. So slow it down. Make sure that what you have to say can be followed and understood by everybody, and it's every bit as important on camera as it is when you're in a courtroom. It's harder for the judge in some ways to interrupt and say slow down without stopping you. So just bear in mind, slowing down your advocacy is a good way of building in that all-important thing for any advocate, a little bit of thinking time to make sure that whatever you have to say matters, is important, and is the right thing to say. Third topic are remotely relax. You won't help anybody if you are stressed out of your good. Now, it's easy to say, but you do have to be on top of everything. You have to make sure that you at least create the impression of somebody who is relaxed. You will reassure your client. You'll reassure your judge. The judge will think, aha, this is somebody in whom I can have confidence. Their presentation is not giving me concern. Their presentation is comfortable and it is relaxed. Don't underestimate the importance of being relaxed. But I'm going to end by telling you one funny story. I had to judge a case last summer. It was a short case. I had to give a judgment to carry matters over. I had a number of cases in the afternoon, so I said, look, to everybody, I need to have a break of half an hour and then reconvene to give you a judgment at 1:15. Can you manage that? Yes, said everybody. I took my break just to gather my thoughts and have a quick drink, and then remembered that between 1 and 2, I was having a delivery of groceries. Oh, well, these things happen. Chances are it will be late, I thought. I prepared at the beginning of my very short judgment, I prepared everybody by saying, look, there may be an interruption, but if there is an interruption, forgive me, I'll answer the door and then return. Sure enough, 5 minutes into giving judgment, there was an interruption. I had to run downstairs to open the door, and I did something that in 25 years I have feared doing, but never done. I stepped over the front doorstep to pick up the box, and the door slammed. That meant that I was outside with a case of barristers upstairs in the middle of a judgment. They were on the phone. They were on my phone upstairs. I had no keys and I was outside with all my groceries, but no means of getting back into my house. Should we say a slightly stressful moment followed? I have a neighbour with keys. I did get back in, but I have to say that lack of preparation by picking up my keys was something I will never repeat. I haven't done it in the previous 25 years, and I won't do it in the next 25 years. So learn from me, be prepared. Thank you.
Michele, Fayyaz, thank you both very much. We'll come back for questions later on. Can I now hand over to His Honour Judge Mark Cawson, Queen's Counsel, and Alice Hawker.
Well, hello. I don't think I can follow that story, to be quite honest. Well, Alice and I are going to look at matters from the perspective of the business and property courts and remote advocacy in the business and property courts. And we're going to focus on 6 topics: bundles, trial timetables, witnesses, skeleton arguments, some considerations before the hearing, and then some considerations at the hearing itself. And Alice and I are going to split this between the two of us. And so I'm going to start by handing over to Alice to just start with bundles, please, Alice.
Thank you, Mark. So in terms of bundles, it seems to me that they've taken on an even greater significance during remote hearings, just given the amount of things that can go wrong and the pitfalls to avoid. So in terms of 3 tips that I think will help with this, firstly, decide early on whether you're going to be using electronic or hard copy bundles, and that way you can plan ahead and circulate copies accordingly. And by extension, check with the judge's clerk whether they would like a hard copy. And if you can't get through, then consider whether a hard copy might assist to avoid any potential delays at the beginning of a trial where the judge requests a copy and you have to try and get it to them. The second point I'd make on bundles is having a complete set of documents is now even more important because you can't physically hand documents up. So do take the extra time to ensure that everything is there, including authorities. And insofar as authorities are concerned, it's usually helpful, especially nowadays, to ensure that a joint authorities bundle is produced so that there are fewer PDFs or bundles for the judge and the parties to contend with. And thirdly and finally, it strikes me that sometimes, particularly on heavier matters where there's a number of bundles, all different PDFs, you might want to create a cheat sheet of where key documents and statements are so that you, and if you're being led, your leader can navigate them easily.
Well, thanks, Alice. Just a few additional points of my own. Well worth discussing the composition of bundles at any pre-trial review, just to see if the particular judge has any particular foibles so far as bundles are concerned. But generally give consideration as to how you're going to split the bundles between themselves. I certainly prefer, if it's a trial, a core bundle, a witness statement bundle, a pleadings bundle, and a chronological bundle of documents. And I don't mind there being several PDFs because one can switch between them relatively easily. So far as type of document platform is concerned, PDFs have worked, in my experience, very well indeed throughout the pandemic. I don't think these more fancy document presentation platforms are necessary, perhaps save for the biggest cases. So far as the actual composition of the bundles are concerned, it's helpful if there's an index at the beginning of the bundle with hypertext links to the documents within the bundle. Not essential, but that I found very helpful. And pagination in bundles has already been mentioned by one of the previous speakers. Very helpful if you can get the pagination in the bundle to match the PDF pagination, so the two coordinate. There's nothing more annoying than having to switch between the two. And something that I've found unhelpful is if replacement bundles are provided. If more documents have to be added, much more sensible to have a supplemental bundle than to try and replace the initial bundle, particularly if the judge has started to mark the bundle up. Well, on that, I'm going to hand back to Alice to look at the trial timetable.
Yeah, so in terms of working out a trial timetable, in my experience, it's really useful to build in rests in the middle of the morning and afternoon, particularly where you are on a remote trial. And I would say for anything really over one day. I don't know what it is, but it seems to me that for advocates and judges alike, remote hearings are just a little bit more tiring. I don't know if it's being able to see everyone on one screen or what it is, but do build in those rests, particularly for witnesses when they're giving their evidence. This will necessarily mean that everything does take a little bit longer. And I know that counsel are notoriously bad at giving time estimates to judges. So don't be too ambitious in what you think you can get through.
I agree with all of that. And I think very important to add extra time to the trial timetable. It is going to take longer. And a couple of other factors, I think, to bear in mind. Broadband hiccups, inevitably something goes wrong during the course of the day, doesn't quite work out, and you're going to waste time on that. And then the need to take instructions, to take breaks from time to time to take instructions is going to add to the timetable. So be realistic and don't worry too much, and I would say in overestimating the length of time. I'm going to hand back to Alice now to look at witnesses and experts.
Yeah, so in terms of thinking about witnesses and experts on remote hearings, I think as an initial point, I would say don't assume that everybody spends as much time as we now do in remote hearings. Witnesses and even expert witnesses might not know what to expect from a remote hearing. So in my experience, they've been really grateful if you set up a short meeting a couple of days beforehand, just to run through what it's going to look like and how it works in practical terms. And this also has the added advantage that you can see where they're sitting, can see how they're set up, and can perhaps offer some practical tips if you think that they maybe need to change room or improve their lighting or work on their broadband. It gives you a minute to be able to discuss that with them. And in terms of your witnesses or your expert setup, I think it's usually helpful to at least ask whether they want hard copy bundles and to arrange those in advance. And I know His Honour Judge Fayyaz Afzal mentioned 2 screens for advocates, but I would suggest, if at all possible, that can be really useful for witnesses, especially where they are using soft copy bundles, to ensure that they can have one screen for the hearing and one screen to navigate the PDFs.
Just to add a bit to that, I think it's very important to impress on witnesses the formality of the occasion. Make sure they dress appropriately. Don't sit there with a cup of coffee. I've experienced both somebody wearing really quite an appropriate dress for a hearing and also sitting there sipping away on a cup of coffee, which is not ideal. Something else to remember, if a witness is going to be taking the oath, then check beforehand and make sure they've got the Bible or other sacred text available to take the oath from. We're going to move on now to skeleton arguments, and back to Alice for skeleton arguments.
Thanks, Mark. So a couple of thoughts on skeleton arguments. I think it's just worth saying, as I'm sure most people are aware by now, that it's particularly important with remote advocacy to consider how you'll best assist the court to navigate the remote bundle or the soft bundle. So resources like a reading list, a dramatist, and a chronology are particularly important, and I've certainly had the impression particularly appreciated by judges that I've appeared in front of. And I mentioned earlier the idea of a crib sheet for you and or your leader, but where bundles or witness statements are extensive, it might even be worth considering a crib sheet for the judge, just to help them navigate those too. I don't know if you have any thoughts, Mark.
Yes, well, that would certainly be very helpful. I think that the key thing is to help the judge as much as you can. I think it is harder preparing for a remote hearing in some ways, so the more you can do to help the judge, and bear in mind the judge is going to have a limited period of time to read the skeleton argument and read into the case. So make the skeleton argument as helpful as possible. Remember, it's your opportunity to create that first impression with the judge. And give a realistic reading time estimate. Don't underestimate it. A judge, I think, would much rather be assigned more time to read the papers than having to cram reading time into a short period of time, not to be properly on top of the case when they go into court. I'm always very helped by a summary of the position at the beginning of a skeleton argument, so that I can see exactly where the advocate's going with the case, and that helps to create an immediate impression. I think also judges help by a neutral factual narrative or chronology. It's very much it helps with the judgment in putting the judgment together if they can rely on a relatively detailed factual narrative or chronology to work from. And in some ways, write the judgment, or certainly give the judge the building blocks from which to decide the case in your favour if the judge is with you, and help them that way. Well, let's move on to look at some steps before the hearing, and back to Alice for that.
Yeah, so before the hearing, I think there's a couple of things that you can practically do just to make your life a little bit easier during the hearing. Firstly, of course, it's not possible to physically take instructions during a remote hearing, so do set up a WhatsApp or a Microsoft Teams group or whatever you agree with your clients, so that you can take instructions during the hearing. I would add a word of caution to ensure that you're only adding your client and your solicitor to that group. I was added to a Teams group on the other side of a case I was appearing in front of a few weeks ago, and did highlight this to them, but it's a little bit awkward for all concerned. So ensure that you're adding the right parties. And secondly, I think it's worth drafting an email with, if you have it, the email address of the judge, your instructing solicitor and counsel and solicitors on the other side. In the event that you do need to remotely hand up a document and thereby circulate it via email, it's very helpful to just have that ready to go so that you can add whatever document you need, rather than faffing around trying to find those email addresses at the last minute. So I shall hand over to Mark for any thoughts on preparation and also at the hearing, and defer to on the hearing.
So I was just going to repeat what essentially Judge Fayyaz Afzal said before about making sure you've got good broadband and a decent camera, microphone. It is important. If you live in the middle of the countryside and don't have good broadband, I think you've really got to get into chambers or go to your solicitor's offices in order to do the case from. I had a case before Christmas where one of the advocates had very good broadband, the other it was going ever so often, even when it was working, it was not a good picture, and it really didn't help. You know, I don't think it ultimately affected the result of the case, but certainly it would have got a lot better if it had been good broadband. Just moving on to the hearing itself, and to say a few things about the hearing itself. Certainly a WhatsApp group to take instructions from does help, and I'm talking from both sides of the fence from this perspective. I was appointed at the end of November in the middle of the pandemic, so I've done hearings both as an advocate and sitting as a judge. But the WhatsApp group's okay, but it doesn't really help if you're being sent message after message when you're trying in the course of making submissions. If you do need to take instructions, then don't be afraid to ask the judge to take a break in order to do that. I think some advocates have said that they are reluctant to interrupt the flow of the case in order to take instructions, but it is an important function of the hearing process, the trial process, to be able to take instructions from your client or instructing solicitor. So really don't be afraid to ask and ask for time to do that. Also, make sure the judge is keeping up with what you're saying. Of course, when you're in court, you can watch the judicial pen or the judicial keyboard and look for those pauses and then carry on making submissions, but it's much harder on screen. So just be more astute to make sure the judge is keeping up and listening to what you're saying and taking on board what you're saying. And I think it's certainly right that cognitive empathy is likely to be reduced by communicating on screen rather than open court. I think that's one of the reasons why we get a lot tireder by doing hearings online, because we are having to concentrate more, because it is harder to take things in. So bear that in mind. Bear in mind the judge is likely to be more difficult to read, and therefore you may have to work harder to get your points across and to make sure the judge has got your points. Of course, the function of an advocate is to get the judge on your side, and I think it probably is harder to do that online, so work harder at it. Also, I found it's much easier online to get the wrong end of the stick, either as a judge or as counsel. So just be very much more careful that everyone's understanding what's been said. So, and a final one, don't pull faces. They're much more obvious on screen than in open court. I think as an advocate, I probably was someone who pulled too many faces, but sitting as a judge, you really do notice it, and I don't think it really helps parties' cases to do that. So just be very conscious of that. I had one, again, the same case before Christmas. One of the advocates had actually complained that his opponent was pulling faces as he was making submissions, and said that it was putting him off. So something to be cautious of. So hopefully that's provided some assistance to you. Obviously, we'll be able to field any questions at the end. I think now I hand over to Karen Walden-Smith, Dr. Walden-Smith.
Thanks, Alex. Thanks, Mark.
Well, good evening. Coming at the end of what I think has been an extremely useful presentation by various judges and advocates. It's always very difficult in that I'm likely to be repeating much of what you've already been told, but sometimes repetition is quite useful as long as it's succinct. And that's possibly one of the arts of advocacy as well. Certainly, it is important to ensure that you have the right hardware, as was said right at the beginning, and sufficient bandwidth to make sure that your presentation won't be interrupted in any way. You need to ensure you're in an appropriate location. You're not going to be interrupted. One of the district judges in my patch had the joy of someone in the midst of giving their evidence having their wife come in with the ironing board and the ironing. So whilst that was a witness who was doing that, as an advocate, you've got to make sure that there are no stray cats, dogs, or children who may suddenly come into your room. Dress appropriately. It sounds obvious, but you must remember you are in a courtroom. You may be sitting at your dining table or wherever you have to carry out your remote advocacy, but make sure you are appearing appropriately dressed. In the Court of Appeal Criminal Division, of course, advocates who have to appear remotely, and sometimes they must appear remotely, for example, if they're in lockdown or for some reason cannot travel into London, then they will be appearing fully wigged and gowned. So if you're in another jurisdiction where you'd just be wearing a suit, still wear a suit. And I don't think you can get away with wearing pajamas under the table either. Make sure there's no extraneous noise. Nothing worse than suddenly some loud bang going off and nobody knowing what that is. But as someone has already mentioned, typing whilst you are in a hearing is not possible, because that typing noise comes across loud and clear. And make sure, if you use any filters, and we all know the great cat story which cheered us all up when everything was looking very bleak, don't use filters other than the most mundane, maybe blurring your background or something like that. Don't rustle, and speak clearly. Michele's talked about being calm. One of the questions that was raised is, how do you appear confident in presenting a case? Well, one of the ways of appearing confident is to slow down and to be quite calm. Another way is to be confident. And if you know your case well and have prepared well, then you will appear confident because you are confident. And I know that that's something that all of you in your advocacy, you wish to do. Now, in appellate advocacy, it is somewhat different because you don't have to deal with the unexpected. You're not dealing with examination in chief or cross-examination. Your witness is not suddenly going to say something you're not expecting, and your expert is not suddenly going to turn around and say, actually, I've changed my mind, and I think what I was saying in my report is actually not right. So you can have a very controlled presentation of your case. And the key to that, the first key to that, is the skeleton argument. Again, it's been set out by my colleagues already, the importance of a well-structured skeleton argument that will take the judge through the case. In a skeleton argument in an appeal, of course, the facts by that stage are going to be settled. And so you can set those out and draw the judge through the story of the case. And what you want to concentrate on, of course, is the legal arguments. And again, I noticed a question with respect to preparation where you're looking at your opponent's case. And of course, in skeleton argument in an appeal court, you're going to want to deal with the other side's case, whether you're the person appealing or whether you're responding to an appeal. And you'll know what those arguments are, so you can prepare and you can set them out. There's nothing different there in a remote hearing as there would be in an in-person hearing. But the important thing with the remote hearing is you're going to have to deal with the bundle and ensure that the judge is able to follow both the documents that might be referred to, but also the authorities. And the more you can set out in a clear, succinct, and effective, persuasive way in your written advocacy before you get to your oral advocacy, the better it will be for you. And because you don't have those difficulties of dealing with cross-examination and presenting the factual case, the pressures are so much greater upon you in bringing an appeal or responding to an appeal, in making sure you are very well prepared with respect to the arguments before the court. Of course, in an appeal court, the judge is much more likely to give you indications of how they are thinking. The facts, as I say, are likely to be settled. And so it really is persuading the judge on the law. So as Mark said, be very careful to try and take note and try and get those indications, those little verbal indications of how you're doing, to see whether you need to expand on some points and maybe persuade more, or indeed you can move on a point. And a judge should be able to give you those indications to say, yes, that's quite a good point, I'm with you on that, without coming to any settled decision, and you can move on. And those points where, frankly, either you're never going to persuade the judge, or you should continue to try to persuade. That really is a canter through as to what I would say with respect to appellate advocacy remotely. As I say, I don't think it creates the difficulties that there may be when you are having to deal with cross-examination remotely, and in particular where you do have interpreters. It is a more straightforward process. And I think in many ways, having had the opportunity to hear cases remotely, they can work extremely well. The important thing is that you prepare very well and present your case, being aware at all times that you need to persuade that judge that your argument's the right one. I don't think there's anything further I want to say at the moment, but I'm very happy, along with the other panelists, to answer any questions there may be.
Karen, thank you very much indeed. Can I invite all the panelists to turn their videos and microphones back on for the Q&A session? And hopefully you'll see your screen fill with faces. Thank you very much. Can I start? I'm going to come to Master Karen Shuman first. I said I would. Can I start with this as the first question? Are those we represent disadvantaged by remote advocacy? And how can we take steps to ensure that they receive the same high standard of care they would usually receive in person? Over to you.
Potentially, yes, if the preparation isn't in place, if the technology isn't in place, and there are extra steps that you have to take as counsel and as solicitors to make sure that your client has the best possible representation before the court. And whether that is simple things, as has been mentioned before, such as ensuring there's a means of taking instructions during the remote hearing, because you're not in a courtroom where you can turn around and take instructions. So there's obvious things that you need to check and make sure, and steps you have to put into place. So yes, it's a system that works. Actually, it can work very well, particularly for procedural matters. I'm less convinced sometimes with taking evidence, but you need to do more work, liaise more with your solicitor in advance to make sure the steps are in place so that your client is not at a disadvantage simply because it's a remote hearing.
Thank you for that. Alice, what's your view from the advocate's perspective on that question?
Thanks. Yeah, I completely agree, if I may say so, that there are potential drawbacks. I had a trial last year in the early stages when everybody was very much getting used to this new system of working, and the other side's main witness, their video simply stopped working. And so my client had to make a decision between either adjourning and hoping that their internet picked back up so that I could see them when I was cross-examining them, or saving the costs and the judge's time and everybody else's time and pushing on as was. And I can understand from a client's perspective that it might seem like this is an imperfect system in some respects, but I think, as has been said by a number of the speakers here today, those negative pitfalls can be avoided with good preparation, and by the advocates in particular, making sure that those steps are in place. And also in recognising that it's a brilliant thing that we can keep going with hearings, and the advantage in many cases to the client of being able to persist with the hearing over an adjournment is probably better than not being able to go ahead at all.
Thanks for that, Alice. Can I move on to a much more practical question? We already heard Judge Cawson's view on this. So I'll go to Judge Walden-Smith, if I may. Bundle PDFs, one single file or one per the old in-print lever arch file?
I think it really depends on the size of the bundle. I quite like having a hard copy as well, if I can. And it was something I was going to pick up on, actually, that I know Alice mentioned about that different judges like to work in different ways. And because remote advocacy can be quite tiring for the advocates and for the judges, and part of that is, I think, just staring at screens all the time. Having something that's a solid bundle can be very, very useful. I mean, certainly having a search facility in a bundle can be very useful as well, that you can just be told it's in tab 13 and you press on it and there it is on your screen. So I'm afraid for me personally, I'm quite greedy. I like a hard copy and it electronically, and I think it's simply on the size of the bundle of whether it can be dealt with. Practical issue, of course, is that some courts simply do not allow many pages to be sent through to them by email. So I think various solicitors firms have found that as a real difficulty. And that, as I understand it, is a work in progress with HMCTS, so it will be better in the future.
Thank you for that. Judge Afzal, anything to add to that?
Just to echo some of the sentiments, I like hyperlinks because it saves you trawling through the bundle rather than clicking on an index that simply takes you straight there. And as Karen just said, the search facility, so if you're aware of a particular phrase or point that's come up and you just can't simply lay your fingers on it or remember where in the bundle it might be, simply putting it in a search tab and having it in a searchable document really helps. And the editing facility and highlighting facility, that if the bundle's well constructed and it's a good PDF document, you can highlight things as you would with a highlighter pen. So that really does help. And that really comes from the documents being a good text format rather than an image, which really you can't do much with other than simply read on the screen, and it's just one block of hundreds of pages. So good bundles really do make all the difference.
So it does seem that the quality of the bundle is really important to making the hearing work. I just wonder, Master Shuman, whether you've got anything to add to that.
Only that remote hearings don't seem to move away from the problem of multiple pagination, which is a point that's been made before when you're referred to electronic page A17 and yours is 33 and you're struggling to find where it is. And that all goes back to preparation. It's preparation for the bundles and it's preparation for how you prepare for your case so that your skeleton argument has page numbers you can actually find in the electronic bundle. That tends to be helpful, I find. The other thing of picking up on what Fayyaz said was that it is very irritating, the subject to how the bundle is created when it's created in such a way that you cannot highlight, because I always like highlighting counsel in different colors. I put sticky notes and things. And if it's, I think if it's just simply scanned in, you have to change its format, and I've yet to solve that, and that's quite irritating. And then I wish I was back onto hard copy bundles. So that's all I'd add.
Thank you for that. Let me move on to the next question, which is this question that's cropped up a number of times in different forms. Do you think that the court process will go back to normal post-COVID, or do you see a future for online working in the judiciary? Let me go to Michele for that.
I can definitely see the remote working staying. I can see it for case management hearings, multi-handed hearings in advance. But I agree with the view that certainly Karen has mentioned, and others, that there is no substitute for oral evidence, oral cross-examination. But I do think that the remote hearing will be here to stay.
Thanks for that. Alice, what's your view from your BPC perspective?
Yeah, I agree. I think that there are certain hearings that work very well online, and certainly from for the much more junior and junior perspectives, it does save you traveling around the lengths of the country, and that's ultimately cost proportionate for the client, and it means less waiting time and all of that. So on a practical level, from a junior's practice, I hope that some hearings are remote going forward. That said, I think for the heavier hearings, the longer hearings, and particularly the hearings where there is oral evidence, I completely agree with the idea that there is just no substitute for being in person, save perhaps if there's an international element. It might be there might be a possibility going forward of blending in video evidence.
Thanks, Alice. And Judge Cawson, what's your view from the judicial perspective?
I would agree with that. From my own perspective, I think there's a danger that we found remote working very easy and very convenient because we can largely work from home, and it all fits in very easily. And so there might be a reluctance to move back to face-to-face hearings from that perspective, which I think would be a huge mistake. I think they are extremely helpful and will continue to be extremely helpful for directions hearings and hearings like that, and a number of other interlocutory matters. But I think for most witness actions, certainly in fairly significant cases, the sooner we get back to face-to-face hearings, the better. And I think there are a variety of reasons for that. One is because I think it lends itself to a fairer and better hearing. And I think a very important consideration is that justice ought to be done publicly and be seen to be done publicly. And there ought to be courts sitting throughout the country where we know that justice is being dispensed. For it all to disappear online and to be happening online where people really can't have access to it is really not a good thing at all. So I think that's one reason why we really should get back to sitting properly as soon as possible. I think also that the formality of it, I think there's a danger. Because we've been brought up doing cases in court with the formality that's behind that's how we conduct our litigation. But I think there'd be a danger the longer we stay online, the more informal hearings are going to get, and in particular trials are going to get. Which again, I think would be a bad thing. So yes, I think it's incredible really. Looking back, none of us a year ago had done a remote hearing. Now we're experienced at it and it's worked fantastically well to keep the show on the road during the pandemic. And as I say, I think it will provide a function going forward for directions hearings and hearings like that. But the sooner we get back into court with most trials, the better from my perspective.
Thank you very much. Judge Cawson's already expressed a view on this, so let me ask it to the other panel members. And the question's put this way. On occasion, counsel has turned off their video when their opponents are cross-examining or making submissions. And the questioner says they hadn't done it before because of the risk they might be disconnected and nobody would notice. But they say this: it would, however, be an advantage if one's opponent is a submissions eye roller or head shaker. We've already heard Judge Cawson's view on that. What about your view, Judge Afzal, on that question?
Well, I think switching your camera off sometimes is an option that people exercise because of their broadband and bandwidth issues to improve either the quality of what they can see or hear from others. So by not relying on the video element, I found that some advocates do choose to switch their cameras off. But remembering it from a judge's point of view, of course, the judge may want to be surveying what advocates are doing and how they are reacting to the submissions that are being made, say, against their cause. So switching the camera off can usually sometimes result in me saying, well, no, don't switch them off without first checking with me. And of course, remembering that I dare say, from the lay client's point of view, they might want to see what their advocate is also doing for the reassurance of knowing that they are there. So I think there are more disadvantages than advantages of switching it off. And of course, if you want to avoid the eye roller or the facial gestures from others, of course, you can't control whether or not you're going to be able to fully do that, because of course they're going to be on the screen sooner or later. I think there are more disadvantages of switching your own camera off, or indeed the camera of others, so you're not seeing their face, because you do miss things, which particularly in a remote hearing, if it's not being said and it's being expressed through gestures or through facial expressions, people may miss that.
Thank you very much. Judge Walden-Smith, did you have anything to add on that point?
Yeah, no, I would agree entirely that there are more disadvantages than advantages. My own view, and I may seem incredibly old-fashioned, is that it's a remote hearing because we can't have hearings in court at the moment for all the reasons we know. But it should be as much like an in-person hearing as possible. And you wouldn't, if you were an advocate in a case, just get up and walk out of court, which is effectively what you've done by turning your camera off. And I think I don't think I've actually had an advocate turn a camera off in the middle of a hearing. And I think if they did, I would be asking them where they were off to. So I'm you know, if somebody said to me that, you know, my broadband's not working, and if I switch the camera off, I can actually see and hear everybody better, then that would obviously be a good reason. But I think other than that, I think everybody should stay on camera all the time in the same way, because the judge does need to control what's going on in court. So I'm quite clear about that. Can I just go back to the thing on are remote hearings here to stay? I'm sure there are cases which will now be dealt with remotely, in that interlocutory hearings will be dealt with remotely. They often were in civil in any event. I think they will be better because we'll move more from telephone to CVP hearings, so that we can actually see the advocates, which is much better than telephone hearings. I really hope we don't lose the general position which we have parties in court being cross-examined in court and being seen and heard in court. I think it's absolutely essential. And as Mark said, there's a real fundamental point about public and open justice, and that means we should be in court.
Thank you very much for that. Can I just move to one of the questions that's been asked live this evening? Does the panel think that the move to remote advocacy has in any way affected the outcome of cases that they've been involved in? Has it influenced the decision or the quality of the outcome? I suppose put another way, has remote advocacy, the move to remote hearings, reduced the quality or adversely affected the outcome of parties' cases? And Michele, can I come to you on that, please?
Yes, I don't think so. I really don't think so. Because in a way, for all of its difficulties, remote advocacy concentrates what you're doing. So I don't think that it has adversely affected it. I think the danger is it's made it much more difficult for quite a lot of people. And by that, I'm thinking of the clients. They don't always understand. They don't always understand what to behave. They will speak when they shouldn't speak. But I think at the end of the day, I haven't felt that any wrong decisions were made because it was a remote hearing.
Thank you for that. Alice, what's your view on that?
Well, my answer is I hope not. It's very difficult to tell. It's something that's quite difficult to quantify. And I think in my personal experience, I've not had any or come across any stories of cases that I expected to go very differently and thought would have gone differently in person than remotely. So anecdotally, I think some comfort can be taken. And also, clearly, people are thinking very carefully in seminars like this and by attending them about how best to use this new resource. And so I think people are alive to the issues and trying to mitigate them. And I do think that there is an onus on both advocates and judges where there is a danger because of particularity about a particular case that a result might be different, to consider how to manage that, and even whether to consider to go and have an in-person hearing. I have one particular case against a litigant in person who is simply not able to deal with remote hearings, and so the court has been hearing it in person. So my answer is no, I hope not.
Thank you for that. Master Shuman, what's your view on that?
I don't think there's been any effect on the outcome, or not anything obvious. I would say that what it has created is the need to be more flexible as a judge. So if there is a reason during a lockdown why there has to be an in-person hearing. It'd have to be a darn good reason, but I'm not sure why that should necessarily prevent that taking place if it is necessary. So certainly I've been more flexible, and I've tried to give people, it probably makes me sound quite harsh, but I give them slightly the benefit of the doubt if phones have rung. I just think because we're in such an unusual environment, because it's not formal as it would be in a courtroom, you need to have a little bit of latitude with things going wrong. But I cannot wait to have hearings back again in court, quite frankly. I know that carrying on, we will have, there are obvious matters, interim matters that would be dealt with remotely. But I long for the days of having people in front of me again.
Judge Afzal, what's your view on this?
I think the hearings are more difficult to manage, and everyone has to work harder. And sometimes the adverse effects are that hearings aren't concluded in the time estimates that they're given. But those are all matters that lead up to the outcome. But I don't think outcomes have been adversely affected because ultimately, as judges, we have to ensure that we are satisfied that the whole process has been fair and that we are able to come to the right decision. And that's why all of those flexibilities that Karen's referred to and the efforts that everyone needs to put into making these hearings work have to be there to make sure that we don't get to that point where the outcome is adverse because of it being remote. And I'm confident that that hasn't actually happened. And in circumstances where the remote process isn't suitable, we can't sacrifice justice. So we will have hybrid hearings, and there are hearings where there have been fully in-person attended hearings subject to maximum numbers being accommodated, and if they can't be, those hearings have been put off to a time when that is going to be possible. So I remain assured that outcomes haven't been adversely affected. It just means that we have to work harder to make sure that that doesn't occur.
Thanks for that. Can I just add this question before I come to Judge Walden-Smith, which is one of the live questions. By relying on technology, are we creating a two-tier system where clients who have better access to computers might feel, who do not have better access to computers, might feel they do not get a fair hearing? Judge Walden-Smith.
Well, I think it's probably sort of been impliedly answered already. If people cannot attend or do not feel comfortable, I mean, can't attend remotely because they don't have the equipment, or do not feel comfortable dealing with matters remotely, then we have in-person hearings. And I mean, before Christmas, I had, a few hearings that were attended by, quite a few people, and they are managed so that people come and go. So I think the thing is that, judges are judges because they do actually have a sense of public service, and they are going to bend over backwards to make sure that the cases before them are dealt with fairly and proportionately. And the whole issue of being actually able to attend court and give your best evidence is something that every judge is going to work very hard to do. So I'd very much hope that there would never be a two-tier system in that way. Of course, there are all sorts of ways in which people have advantages and disadvantages when they're in court, but I don't think remote advocacy is going to feed into that anymore.
Thank you. And finally, Judge Cawson, anything from your perspective on that question?
On that question, no, I just that judges, I think, have got to be very careful to ensure equality of arms, as it were. And if there is a litigant who obviously isn't able to get online or is having difficulty in communicating online, then we've got to find a way around that. And if that means a personal hearing, then a personal hearing it should be.
Thank you very much. And just with an eye on the time, final question. I'm going to come to each member of the panel for this. And it's one of the pre-submitted questions. If you restarted your advocacy journey from the very beginning, what would you do differently? Michele.
I think what I would do is plan my career a bit more strategically.
Thank you for that. Judge Cawson.
I'm frankly a bit stumped by this.
Well, if you've had the perfect career, I suppose nothing to change.
Well, I've certainly not had that. I don't know. I think possibly watching others a bit more and studying different advocacy styles a bit more, and to see what I could learn from that. And I read someone who said that they spend their time in retirement watching the Supreme Court and watching advocates in the Supreme Court. And although they've now retired, indeed retired from the bench, how much they felt they'd learned from sitting there watching different advocates and different advocacy styles. So I think that's probably what I would say. Yeah.
Thank you very much. Master Shuman.
I would have applied to be a part-time judge, because I went straight from full-time practice to being a full-time judge. And I see so many things that are different as a judge than when I did as a barrister. And just an appreciation of what you need, what the tools are that you need as a judge, what help you need from counsel. And I think that would have enhanced my practice, or certainly the service that my clients and solicitors received. So that's what I would have done differently. I don't think I didn't marshal, actually. I might have marshaled, but I think really when you're in practice a little bit and you do some judicial shadowing, and then you perhaps then become a part-time judge, that gives you a really useful insight.
Thank you very much. Judge Afzal.
I'm really struggling, much like the rest of the panel. So it shows it's an excellent question, because it stumped most of us. You know, I did have the advantage of being a fee-paid judge, so I did get to see things from the perspective of from the bench and from advocacy, and it did influence my advocacy because I realised that those points that we routinely trot out sometimes as barristers weren't so well received when I was sitting as the judge. So it did modify that. But I think I perhaps would have got more involved with, for example, advocacy teaching. I did so quite early on in my bar career, but I think I might have actually got involved even sooner, such as the student activities weekends and things like that, so that I didn't necessarily have to wait until I was actually eligible to teach advocacy to be involved in it, because as has been said, observing and learning is just hugely advantageous. So when I did start advocacy teaching, it again, not only did I hope help those I was teaching, I learned from it myself. So to do it even sooner as a very junior advocate, so less than 7 years, call say as a witness or on the student activities weekends, might have been helpful. So I think if I were to do it again, that's what I would actually add. So earlier and greater involvement with advocacy teaching.
Thank you very much. Judge Walden-Smith.
Well, all of the above, of course. Fayyaz has been a brilliant advert, I think, for the advocacy training. I think watching others is really important, whether you're doing that as an advocate, just going to sit in court occasionally and see other people's advocacy. I think one of the other things I'd say is don't be fooled by the apparent confidence of those around you. I remember when I started in chambers, and my roommate was unbelievably confident in everything he did, and I felt very underconfident in everything I did, and I had to sort of teach myself that actually he doesn't know anything better than I do. It's just an act. So be confident in yourself. I mean, obviously earn that confidence in yourself, but that's, I think, what I would say to a starting out me.
Thank you very much. And Alice.
Well, I'm struggling to pick just one lesson. But I think my lesson to those starting out that I wish that perhaps I'd taken a better note of is, and we've discussed it here today, the importance of both written and oral advocacy. I think I placed initially a great deal of weight on oral and perhaps undersold to myself the impact of good written advocacy. And so I think that the more people starting out can get an experience of both written and oral advocacy, the better, whether that's by compiling skeleton arguments from minis and marshalling and just going through them and looking at what works. I think it's really important to make an impact before you get to court, and that's a lesson that I've certainly learned along the way.
Thank you very much. Thank you very much to all our panelists and to all of you for joining us this evening for the session. I hope you've found it useful. Most of all, thanks to Emma Jeffrey from Lincoln's Inn Education Department for putting this together, because literally without her, this would not have happened. So sincere thanks to you, Emma, and back to you for any closing remarks.
No, thank you so much, all of you, for giving up your time and your wisdom, and for spending so long answering questions. We had many, many more questions, but you did such a brilliant job, David, of picking out some great ones. We've got lots of messages in the chat. Thank you all for a really, really helpful event. So I think you've helped a lot of people this evening. Thank you, everyone, for joining, and have a lovely evening. You are now free to go.
Thanks, Emma.